Hello, everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is collaboration tips for deposition and motion prep. Speaking today will be Jamie Carruth and Daniel D'Angelo. Daniel D'Angelo is the Director of Data Strategy at Nextpoint, where he provides consulting services that help clients minimize e-discovery data expenses. Mr. D'Angelo has over 10 years of experience in litigation consulting and has managed cross-functional teams in over 25 on-site trials, arbitrations, mediations, and jury exercises. He earned his BA in computer engineering from Northwestern University in 2002 and is currently pursuing an advanced degree in predictive analytics. Jamie Carruth is an associate attorney at Whatley Kallas, practicing in healthcare litigation, antitrust, product liability, consumer protection, complex litigation, and class actions. Mr. Carruth is a member of the Alabama Bar and is admitted to practice in the United States District Court for the Northern District of Alabama. He received a BA in political science from the University of Alabama, Tuscaloosa in 2001, and a JD from the University of Alabama School of Law, Tuscaloosa in 2004. The Industry Insight webinar series is hosted by the ABA Legal Technology Resource Center. To stay updated on upcoming webinars or view previous videos, visit ambar.org/industryinsight. You can also stay updated on legal technology news through our blog, lawtechnologytoday.org. The presentation today will be followed by a Q&A. Please enter your questions into the question box in the webinar panel on the right side of your screen. All questions will be addressed at the end of the presentation. We are also recording this webinar, and we will be sending the video in a follow-up email in a few days. We'll post the video on our blog as well, which again is lawtechnologytoday.org. Thank you all for joining us today, and we'll now begin the webinar.
Great, thank you, Rose. I'd like to thank everyone for attending and for Jamie for lending some of his expertise today. Today we're going to cover some tips for your collaborating on your deposition and motion prep, really going beyond discovery and what you've done in a review, and then using technology to assist as you prepare for trial. Today specifically we're going to cover setting up and creating a repository for your documents, how you can go about sharing key evidence with the different parties that you may be collaborating with, some best practices for using this repository of evidence in your deposition preparation, and tools for keeping your team on track as you prepare for your case. So the first question we're going to answer is, how will your evidence be stored and where will you store it? There are a number of considerations to take into account. Of course, these depend on the size of your case and who you're working with, but we're going to focus on access to the evidence, how you securely access that evidence, what you can do with the evidence once you have it in a repository, how you track it, how you organize it, and then how you capture any of your work product and report out on that.
And Daniel, I would also add, of course, you're going to want to consider the volume of when making these decisions. It's important early on in the process, and especially during the meet and confer stage of a case, to get kind of an idea of what the volume of documents you're going to be looking at, what kind of type of review you're going to want to do. Are you going to use a technology-assisted review, or is it going to be a small volume where you're going to want to do a more linear review? And of course, the cost is always an issue depending on your clients and the type of case and how much you're going to invest in a case. You're obviously not going to treat a straightforward car accident case the same way you're going to approach a national class action antitrust case.
Right, thank you, Jamie. I think that's a great point. I mean, cost and size are always going to be issues. Hopefully, one of the things that we can also see here today is that, even some of this technology and pieces of the technology can help in cases of any size. So it is important just to know your options. The first one we're going to talk about is email, and that might seem strange as a storage option, but I wanted to touch on it because we've seen, I think there's an ABA legal technology survey that said 90% of lawyers still collaborate with documents over email, and it's really just built in and integrated with all the business operations. So I did want to touch on it. It's not really ideal for managing the evidence in your case. There are lots of reasons for that. Depending on how your email is set up, it might not be very secure. Attaching documents, you may get returned emails for the size of the documents. There are limitations to that. And also, with the volume of email that everyone has nowadays, it's difficult to search and organize these things by your issues. It's also a little counterintuitive, but email is not a very collaborative medium. You're emailing back and forth to people, but it's not a group setting. Everything's sequential, so it can get difficult to carry on conversations. Some of the other options you have as far as setting up and securing your documents are some of the cloud applications that are prevalent nowadays. Google Drive and Box and Dropbox are very popular. They're cloud-based. They offer some security features. They offer a lot of access and mobility. Our recommendation would be that they have some utility. They're a great way to store some work product. It's probably not the best idea for litigation-specific evidence and documents due to some of the security settings and confidentiality concerns. There isn't also a lot of built-in functionality around some of the workflows that lawyers use. So it may not be the ideal medium, but there definitely could be some options here, again, depending on case size and what you're trying to do. The third option, and this is what we actually would recommend, is a litigation-specific tool. Now, I would make a distinction here with the more of your review type software. I know a lot of lawyers still use that. They'll go from discovery to trial prep in that same software, in that same database. And that has a number of advantages, around the functionality of searching, organizing, tagging documents. What I do recommend is actually maybe thinking going beyond your review database and having something specifically set up for your trial prep. And that gives you a number of benefits around a more limited universe of documents. Once we start talking about trial, we can start looking at depositions and having functionality around those, tagging transcripts and looking at deposition video, and even going towards your trial presentation. Jamie, have you used any of, I know you're a client of ours, so full disclosure here. You've used some of our software. Nextpoint makes an e-discovery tool, but today the screenshot here is looking at our prep tool, where we do have some of these functionality. Jamie, can you speak to a little bit of your experience in using these for prepping for deposition?
Yeah, absolutely. I've used several different types of software platforms, and one thing I like about Nextpoint is you have your review database where you have all the documents that have been produced that you can code for various issues and whatnot, and then you can export only what I like to call the hot documents that pertain to a particular witness or a particular issue into a separate prep database, which is what the screenshot shows here. And that's useful in that you can focus on what's really important. And if you're going to a higher level, or somebody who hasn't necessarily been as involved in a case is coming in later and is preparing, whether it be for a deposition or a certain motion, or even preparing a certain witness at trial, you can set up as many different of these smaller types of databases as you need. And you can include things, you can search for certain issues that have been coded as hot, or as, whatever issue it is you're looking for. You can search by, the name of a deponent, for example, and one of your issue tags. And so it's a useful tool for getting, I think, for getting people, what they need and not things that they don't need.
Great, thank you, Jamie. Another thing I'd mention here, whether it's Nextpoint or some other, database review trial software you're using, one of the other advantages of having a more of a database approach to this problem is having your users and giving them access and only access to certain documents, whether that's through, as Jamie was saying, having a more limited database or a separate database. But really that accountability and the audit tracking provides a level of security that is very beneficial. With that, I want to talk how we would start to collaborate and how do we get people, the key parties in the case, these documents and evidence. Now, there's several people and different groups of people who you'd want to share, your evidence with. You're going to have your internal trial team. You could have co-counsel. You could have to send documents to opposing counsel, your experts, your own witnesses when you're prepping them, your client, and even potentially the court. So there's a varied amount of parties, and they're all going to have different access levels and what you want them to see. So you really need to think about what you're trying to accomplish and who you're giving these documents to. You do have a number of options for getting these documents over. We want to consider the timing, of course, the security and how we're going to deliver these files, whether or not we're just delivering loose PDFs, or we're going to send over a whole entire database that does have some of that functionality we were just talking about. If you have to track and produce an audit trail or a chain of custody on the documents, and then again, I'm going to say again security, which is just a very important issue. You really can't be too secure. We've seen a lot of the, in recent days with WikiLeaks and whatnot, having data electronically does open you up to having hacking and whatnot. It's important to make sure and look at your security procedures. So some of the things we see our clients do when they're collaborating and trying to share documents with people, the first one is just shipping the data. So putting documents onto a CD or a thumb drive or a hard drive and sending that through the mail or FedEx. It is very prevalent still. We see a lot of our clients use it, but it does have some drawbacks. It is slow. You need to export those files and put them on a CD. There's really no audit trail outside someone signing for the package. The size could matter on how you're transferring these files. You need to consider the media you're sending these files on. CDs can break. Shipments can get lost and damaged. So there's a lot of downside to actually just shipping the files. So there are other methods that are a little more secure and a lot faster.
And I would, if I could interject, I would just say that sometimes I try to avoid shipping documents as much as possible for all those reasons that you mentioned, but sometimes it can't be avoided. Sometimes you have a client that insists on, wanting to have a hard paper document in front of them. I recently had a client that had vision problems and couldn't look at stuff on computers, so we needed to blow things up and get larger pieces of paper that he could physically have in front of him. One thing that I would emphasize when you do have to ship documents, always make sure that it's clearly labeled as attorney work product or attorney-client privilege, as appropriate. I had an instance fairly recently where our carrier delivered something that was supposed to go to a client to an address that was very similar to what, where we had addressed it, but unfortunately was the wrong address and actually happened to be the offices of a person who was sympathetic to the adverse party. So if thankfully nothing nefarious happened, and but if it did, we at least would have had some recourse because we had attorney-client privilege, attorney work product, prominently stamped all over everything. So just keep that in mind if the situation arises where you do have to ship documents.
Great, thank you, Jamie. The next option for sharing your documents are some of the apps we talked about in thinking about a repository for the documents, but in actually transfer them. Some of the same things apply with the Dropbox and Box and Google Drive. They're a good medium for storing some documents. Here you have some file size considerations and transfer speeds. Also, you don't know what your receiving party knows technology-wise. There is some learning curve in setting up, the apps themselves. I would say that same thing with some of the other common practices we see with FTP sites. Firms will have their own FTP site they'll share files with, or some of the other kind of hybrid between app and FTP sites, these share file sites that allow you to share larger files. We do see it's a lot mostly for production, so it's a little bit earlier in the process, and they're good for larger type files like ShareFile, for example. I see a lot. It's a Citrix product, and you can send a link and download these files. But there's not much more around them. It's really just a file transferring system, and it's up to the parties to do what they will once they receive those documents. It is good. It gets around some of the, Jamie was just addressing some of the difficulties in mislabeling or having the wrong address. Here you're sending different usernames and passwords, so it does provide some more security, more than mailing, but not as much as we're going to look here in option number 3, which is what I would call exchanging an electronic database. Again, this is kind of where we see our clients and push our clients towards actually not just having your own discovery database and trial database, but when you're transferring files, transferring that same functionality to your receiving party. Now, this is one of the cases where you're going to want to consider who you're sending the information to. You may not want to send your opposing counsel, for example, a searchable database, but you might want to send your client one, give them limited documents or an expert witness. There's a lot of functionality there that could help those types of parties in your collaboration. It is faster than sending over mail. You're not having shipping expenses. You can control more granularly the security and authentication. And then another added benefit I really like is the ability to keep an audit trail, so you can see who is seeing the documents. For your experts, you want to know what they're working in. And this gives you the ability to see what documents they've laid eyes on. Jamie, have you ever used something like this for your experts? How do you tend to send them documents?
Yeah, and like I was going to say, I find tools like Dropbox, for example, I think those are more appropriate for collaborating with co-counsel. It's useful if you need 2 people to be editing a document at the same time if you're working on a draft motion or something of that nature. I've used the electronic database exchange programs for getting documents to expert witnesses. It's particularly useful. A lot of times you'll have an expert that's addressing one particular aspect of your case. For example, you might have a damages expert, and so you might set up a code in the review process for damages or financial information or that sort of thing, and then you can filter by those documents that are likely to be interest to that particular expert, and set those into a database and electronically exchange, and then that gives them the that gives your expert the ability to run his own searches or do whatever he needs to do within those documents, and preserves the work product any kind of work product you've already put into it. So I think it's very useful in that. I've used it a good bit in that context.
Okay, thank you, Jamie. So once you have a repository of documents and you're exposing those documents to the parties that need them, and you're collaborating with your teams now, I want to shift a little bit and talk about how we're going to use those and these tools for going into your motions and your deposition prep. So, and Jamie can speak to some of this. He definitely has more experience than I do.
Right.
What we see for clients here is we tell our clients to, as you're tagging in, as opposed to your relevant review, now you're getting to specific issues. And on top of that, you want to start tagging your documents around specific witnesses. Some of the things that we see that are helpful are not only just tagging, but putting the documents in chronological order so you can start to come up with your story, come up with your list of events, and then all toward building an outline. Once you get that outline built, I'm sure there's going to be lots of revisions, and as Jamie was saying, you can share some of these with your team and work on different versions. And tagging these documents in this way allows you to go back and forth with the team and quickly point out in one place where those documents are without having to worry if they have that same PDF that you sent them before. So again, this is an advantage of having one of those databases. You know what documents everyone has access to.
And Daniel, I would suggest building an outline, even at the very beginning of a case. Think about, even before you start reviewing documents, I think you should have an outline. If you're on the plaintiff side of the elements that you have to prove, and how you think you're going to prove them. And of course, it's going to be it's going to change as the process goes along. But I think it's important to kind of know what you're looking for, on the front side, whether you're on looking to build a case on the plaintiff side, or whether you're trying to build your defense on the defense side. I think it's a good idea to kind of have that framework to work from on the front end, and then as you discover new information, of course you can always change it. But I think it's important that you do that on the front end, so that you kind of have a framework that you're working towards.
Great. So once we have these outlines and we're actually getting into our depths, you're going to want to prepare your witnesses, obviously. Now, a lot of times I've seen attorneys just have big binders of printouts. That's definitely effective for taking notes and whatnot. It's not always the most either cost-effective. It's difficult to ship those to witnesses. You're not always in the same place. So it is good to think about how you can organize your database and maybe give some limited access to your witnesses. You can start to share documents that way. I know our tool has actually what we call Theater, which is an annotation tool. Something you can do callouts in. I've seen definitely some of my clients use that for their witness prep, showing the key sections of the documents, actually how they may look on a screen as we're going to see them in a depth. Another important thing to do is actually start to incorporate previous depositions. You want to make sure that you have all those transcripts, and not only just have the transcripts, but be able to search on them and issue code them, so you can build off of your previous depositions. Putting all this evidence into one place is really help you be efficient about that. Okay, the final thing I'd like to talk about today, again, I'll lean on Jamie here, is actually keeping your trial team on task and making sure that you're hitting those deadlines and keeping everything front of mind. There's some technology around this for you, but really it's just about how you like to organize a team. These teams are going to vary depending on the size of your case. It may be an all-internal team. It may be all those parties we were talking about earlier. I'll let Jamie talk about some of these bullet points here because I know they're things that are in front of his mind.
Right. Thanks, Daniel. There's a lot of law practice management software programs out there. I'm not really, advocating any particular one over the other, but most all of these are a comprehensive place where, you can store everything that's been filed. You can profile in all the different correspondence, contact information for opposing counsel and co-counsel and parties and witnesses. And I would encourage everybody to use one of those types of programs, because it's just helpful to have everything in one place. Most of them have some sort of calendar function. Others have, time recording functions, that sort of thing. I would always designate at least one person. It can be a paralegal, a lower level attorney, really doesn't matter who, but somebody that will keep up with all the deadlines of the case. As soon as discovery is served, as soon as something's filed that has to be responded to, there needs to be somebody who knows that that needs to go on everybody's calendar. Personally, I like to just use Outlook because I have it in my mail anyway, and I can get my calendar's right there, and I can get notifications. But there's tons of calendaring type programs out there. Make use of them, and not only have one person, but have somebody else making sure that that's getting done. You don't want the one person that's responsible for that to be on vacation and you miss it to respond to discovery or something like that. So make sure that that's that you're cooperating with one another on that. Getting progress reports from the trial prep team. There's usually a number of projects that will be going on at any one time in litigation. This is especially important to me in the doc review phase, and again, it depends on the type of case and the volume of documents that you're dealing with. And like I said, it's important to kind of be able to anticipate that as early as you can. It's good to figure out as much information as you can in the meet and confer process about how big of a database that you're going to be looking at. But I typically, if there are multiple people reviewing documents on a case, I want to, depending on the deadlines and the volume and whatnot, I either want daily or weekly reports of, what types of documents are you seeing, who the custodians are, any hot documents that we should be thinking about using in a deposition. If there's anything out there that hurts our case, we want to know about that. The sooner the better. And I think it keeps your reviewers engaged in the process, and it kind of keeps their mind sharp, and that they know that they're looking for these things to prepare these reports. And it also helps, if you're a managing attorney, it helps you, manage the project. You can, figure out if you need to add more reviewers, need fewer reviewers. If you need to, perhaps there's another claim that's been uncovered. Perhaps you want to amend your, complaint, or you want to amend your answer. So it's just good to get those, get those frequent reports. And along those same lines, I think it's easier said than done, because I think we all know in this world that scheduling is never easy, and the more people you have involved, the more difficult it becomes. But at least once or twice throughout the litigation process, I think it's good to have an all-hands meeting. If you can't have, with my firm, we have more offices than we have attorneys, so it's impossible to get everybody together in one place. But even if you have, everybody jump on a conference call, people who are reviewing documents, paralegals, support staff, everybody that's involved in a case, I think it's good to spend 30 minutes or an hour, however long it takes, just to get an update from everybody on what they're working on, how it's going, if anybody has any concerns. It helps everybody kind of see the big picture and realize how what one person is doing relates to what somebody else is doing. And so I think it's important to make sure you have those communications and have those meetings to keep everybody on the same page.
Great. Thanks, Jamie. I'll just add here, as Jamie said, there are lots of softwares out there that can help kind of keep everyone on point. But really the most important thing is just making sure whatever you use, that people are going to adhere to it and people are going to use it. If you go and do a project management software and the one person is setting deadlines and milestones and whatnot, if no one's going to adhere to updating those or keeping the meetings and whatnot, it's not useful. So just keep in mind what the level of your team is, and make sure you can work out a process that's going to actually help make things more efficient. Before we take it for questions, I just want to We actually, Nextpoint, put together a more detailed checklist for preparing for your depositions. Today we only had 30 minutes, so we didn't get into a lot of detail, but we have checklists and tips for video depositions specifically. This will be available via this orange link here when the slides come out, or you can visit the white paper section at nextpoint.com.